And now to greet you and I is that famous attorney at law, Mr. Raja Bhandari. Mr. Bhandari is from the law offices of Attorney Raja Bhandari in Sex and Settlements. This afternoon, this well-known attorney will guide us on and about a nominating guidance. Let's see.
Good afternoon, this is Raja Bhandari from Law Offices Raja Bhandari and Sex and Settlements. Welcome back friends to Kanun. It's your segment, your questions, and we are trying to do the answers. Now let's take it again. The next question we have in reference to estate planning, but this is very interesting question. This is a question on the guardianship. A person should appoint a guardian for the children if they are under the age of 18. As you know that recently there was a very bad incident in our area that young couple died and they have minor children, and those children been put in the foster home, and their grandparents came from India and they were not able to let them meet those children for almost 3 to 4 months. It was a very bad incident, and finally things settled down, and then they released the custody to their grandparents, of course the intervention of the court. This can happen rather with anybody, anywhere, if you don't have a proper legal document as far as guardianship is concerned. Now the guardianship for the minor children can be made in a different way. Of course, if you have a will, you can appoint a guardian for the minor child to take care of their boarding, lodging and education according to your wishes, and your assets will be distributed accordingly the way you want. If you do not appoint a guardian for your children, of course, I just relate the story to you, it can happen. So this is a very important issue. Now the same thing can happen to, I just want to take the question a little different route. For the, let's say that a husband and wife don't have any will or any document, any power of attorney between each other. If a person, one spouse gets sick and incapacitated, not in a position to speak or anything, and he or she is the owner of certain property, and then the other spouse cannot do anything because her name or his name is not on that particular asset. Now friends, it's going to be a very, very touchy subject. Of course, when the person dies, you can go to probate section and open the estate, but the person is alive and you do not have any document to that effect so that you can manage his or her affair during his life. Of course, he is, let's say, incapacitated. In order to have a guardianship of that person, you have to go to court. And a court is not an easy to deal with this particular issue because they want to have all the doctors, if not, because the judge wants to make sure that the person is incapacitated, the treating physician should be coming over there and testify. Sometimes they take affidavit, but sometimes they want them to come and testify that the person is not able to do anything, so the custody should be, or the guardianship should be provided to the other spouse. However, anybody can else challenge to that effect. So in order to have guardianship in that case, you can imagine how much can cost a spouse or the estate later on for that person. So please make sure, anything can happen to anybody, anywhere. So please make sure you have a proper documentation for the minor children as well as between the spouses. So let's say that if a husband and wife appoint a guardian A, husband appoint a guardian B, that is not going to happen. Then court will decide that they have to appoint a guardian third party because there is a conflict now here. The best way to handle the guardianship is to prepare a trust agreement. Trust agreement is basically an estate planning. In estate planning, you have a detailed section that you say that, for example, let's say that you have kids at the age of 14, 15, 16 or 18, whatever the age is, let's say that. In that particular trust, you are appointing a successor trustee that in case something happened to us, me or my wife, that successor trustee will handle the affairs of the trust. Means I have 2 kids, they are minors, and then please do not distribute the property to them until they are 25, 30 or whatever the age you want to mention, and during that time please take care of their education, food, lodging, whatever their requirement is until they become 25, and then distribute the property accordingly, whatever your wishes are. So please make sure when you prepare a trust, not only you giving yourself a favor, also you are giving a precious gift to your kids, so that way they don't have to go here and there, their trustee, successor trustee or the guardian in a way, in layman's language, has been appointed, so that particular person can take care of your kids as well as you, in case, for example, let's say that husband and wife both get incapacitated and they are not able to make decision and they have a minor children. Who's going to take care of that? Their successor trustee, they appointed in the trust. So the trustee has to do is that the successor trustee has to take care of the spouses first, then at the same time for the kids. So friends, this is a very important issue when it comes to guardianship. Guardianship is a very broad word that can be taken, you can, as I mentioned, that main goal is that your kids and yourself should be taken care by the legal documents, so you don't have to court and you have to taken care properly by the successor trustee or a guardian. Friends, this is the question regarding the guardianship. We will take next time different questions. Of course, it will be your question, our answer. Thank you so much for joining us today. This is Raja Bhandari taking a leave. So long.